A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. Glad you're with me on the program today. As promised, Jim Wallace of the Gun Owners Action League is going to be with us here in just a moment or two to talk about some good news in the case of Commonwealth versus Kulada. Kyle Culotta, the Air Force veteran who was jailed for 4 months for possessing a firearm without a license. The only reason, by the way, that Kyle is out is because Massachusetts Dangerousness statute has a 120-day time limit. So after 120 days, if you're deemed to be dangerous, you can still you are eligible for bail. And that 120-day threshold was reached. Kyle Culotta declared dangerous for simply possessing firearms in Massachusetts that he did not have a permit for. Legally owned in Arizona, where he's from, legally purchased. Kyle has no criminal history until he was again arrested for violating Massachusetts draconian gun laws. But the simple fact that he possessed a firearm without a license, something, by the way, which is not a crime in the vast majority of states, that alone was enough for not only prosecutors, but judges, plural, to deem him so dangerous that under no circumstances could he be allowed to leave the jail. It is infuriating. And even though Kyle is now out of jail, the prosecution and the persecution, of Kyle Culotta continues. So let's talk about it with Jim Wallace, Executive Director of the Gun Owners Action League. Also talking with Jim today about Goal's lawsuit, along with the NRA and several individual plaintiffs challenging the new and expanded ban on assault-style firearms, is what they call it in Massachusetts. The lawsuit filed back in August. The Attorney General's office replied this week with some extremely dubious assertions, let's put it that way. And we also talk about that with Jim in today's conversation. So, again, take a look and a listen. Jim, thanks so much for coming on the program. It's good to see you, my friend.
Well, it's always good to see you. You know, the bearded wonders get back together, right?
That's right. There you go. That's right. And for once, we got some news to talk about. We also have some good news to talk about, and that is a rarity in Massachusetts. We have been following the case of Kyle Culotta since late July, when he was pulled over for a traffic stop, basically what I think was an expired tag. For those who don't know, Kyle and his girlfriend lived in Arizona. They were on their way to his girlfriend's family, basically living out of their car at that point. They were making money door dashing. The officer was going to have that car impounded, which was already bad enough. Kyle let him know, hey, listen, I've got some legally owned firearms in there. And even though he lawfully purchased them, lawfully possessed them in Arizona, he did not have a Massachusetts permit. So Kyle was arrested. He was declared dangerous by a judge based on a prosecutor's request, and he was held without bail. Jim, was he held without bail for the full 120 days that the state allows?
Yeah, he was. Yeah, he was in there for 4 months. He was actually declared dangerous by both the district and superior court, because in the Massachusetts, what they call the Dangerousness statute, one of the bullet points in there, if you will, is mere possession without a license. No other underlying factors, which to us is so unconstitutional, it's not even funny, that essentially a paperwork crime gets you labeled dangerous. And Kyle had a clean record, Air Force veteran, a CDL driver, so you know his record was clean. But yeah, as soon as they processed him, and he got went before the judge, they declared him a dangerous individual.
I'm sorry, I want to skip ahead a little bit here because Kyle's girlfriend reached out to the Gun Owners Action League, and you guys said, okay, we're going to help out with this, right? You were able to get attorney Dan Hagan to represent Kyle. He had a public defender, and no offense to public defenders, but they've got a lot on their plates, and so to have a private attorney handle Kyle's case, I think is just better, quite frankly. And Dan was able to get the most serious charges dropped But that still didn't change the fact that the courts considered Kyle dangerous, even though he wasn't even facing the most serious charges anymore.
Right. Yeah, which is, again, just ridiculous. Now, the interesting thing is, and Dan was using this as an example, that he had a real criminal client just 2 weeks ago or something like that. The guy had previously done a home invasion and was out on bail. And I think the story is that while out on bail, got caught carrying a gun illegally and got bail again. But yet Kyle is a dangerous individual. Now, a month or so ago, there was a man on I-93, which is, a major interstate here, that cut off a woman with his truck, and she beeped at him. He stopped his truck in the middle of the interstate, got out and shot at her, and was out on $3,000 bail.
Yeah.
But Kyle, one of the things that we continue to think about is, did they actually punish him because we got involved? Or did they get caught with their pants down and then they couldn't back off? So, there's just no common sense or even legal sense as to why they held this guy.
Yeah. Yeah, I mean, again, based on those other cases, and we covered that road rage case, I think it was a little bit more than a month ago, but we covered it at the time, and we noted like different counties, right, different judges, but still, it's the same state law. And if that guy's not dangerous, then why the hell is Kyle considered dangerous? I mean, it's just it is a legal absurdity, but we can't laugh about it because Kyle was in jail for 4 months, and he could go back to prison. I mean, that's the thing. The charges haven't been dropped, right? His next hearing is in December. So they're still zealously prosecuting him.
Yeah. That's his pretrial hearing, I believe. So it's going to be interesting. But I'll tell you what, kudos to the Second Amendment community for helping support Kyle. And, it's kind of funny, Cam, because when we first decided, because we've never taken a case like this, it doesn't happen. But when we first decided to do it, we actually got a little pushback from the Second Amendment community here. And some of them were saying, well, he's a criminal. He didn't have a license. And we had to kind of gently tell our community, have you been living behind enemy lines so long that you think it's okay to imprison somebody with no other underlying factors just because they possessed a gun without a license? And it was almost like even through the keyboard, you saw them go, oh, yeah, wow. But that tells you how long they've been living under this stuff.
Yeah.
But it's kudos to everybody who helped out. Now, his fiance set up one of these funding things online for the bail. And once we knew he was eligible, we put out, here's the link that they raised that $10,000 within, I think, 5 or 6 hours to get him out. So
that's amazing.
Yeah, people from all over the country who had heard about this were eager to help him out. It was not appropriate for Goal to use member money for bail. We can use it for the litigation and the legal defense, but not bail. And but I'm so proud of the Second Amendment community for coming around behind this guy. But we still got a long ways to go. He's breathing some free air, at least for now. And, I hope to see him very soon, meet him in person. I still haven't. But we're being respectful, giving the guy some time with his fiance and chill out, maybe have a cheeseburger or something, whatever he wants to do. But, it's really exciting. But the fact is, too, even Dan, and I'm not going to speak for Dan, but this guy was so dangerous that we had to keep him in prison for 4 months. But when we finally said, okay, you can have bail, there were no conditions on the bail. It wasn't like they put a monitor on him or said you're under home arrest. So he was so dangerous, but nothing makes sense.
Yeah. You're right. Nothing in this case makes sense other than, as you say, maybe Kyle was being punished for, gun owners actually getting involved. I hope that wasn't the case. Maybe it was a case of prosecutors not wanting to back down. Again, hope that wasn't the case, but whatever. There's just no justification for how this case has gone down so far.
No,
There just isn't.
no, but we're super happy for Kyle and Saranda.
Absolutely.
Super happy for them. Yep.
And we're going to keep paying attention to this case. I know that there's, not a lot. I've thought about reaching out to Dan Hagan. I don't know how much he can talk about the case while it is still ongoing. So, I'd love to have him on. I'd love to have Kyle on, but it's probably not in Kyle's best interest to go do media appearances right now. So we will continue following this case as closely as we can through proxies like yourself. But again, if folks want to help out, you can donate to the Gun Owners Action League. There's a little place where you can leave a memo. Just say you'd like this to go to Kyle's legal defenses, and that money can be directed there. I do want to also ask you, Jim, about Gun Owners actually playing offense here. A lawsuit filed back in August, along with a number of individual plaintiffs, the National Rifle Association, challenging the new ban on so-called assault weapons under Chapter 135. This is the second lawsuit that Gun Owners actually has filed related to Chapter 135. The first one actually caused the state of Massachusetts to go back and say, never mind, we're not going to actually enforce this for another 18 months in an attempt to get that lawsuit declared moot. And mootness is, ripeness is one of the arguments that the state of Massachusetts is making, saying that, this case isn't ripe for litigation yet because the new provisions haven't gone into effect. But the main affirmative defense offered by Massachusetts in their reply to your lawsuit is that they're immune from being sued over violating the Second Amendment rights of Massachusetts residents because of the 11th Amendment, which I confess I'm not an 11th Amendment expert, Jim. So when I saw that was the claim, I had to go and look at what the 11th Amendment said. And I'm paraphrasing here, but basically the 11th Amendment is supposed to prevent foreign nationals, citizens from other countries from suing in federal court, as well as like if I couldn't sue challenging Massachusetts assault weapon ban because I live in Virginia.
Right. Yeah.
But your individual plaintiffs all live in Massachusetts. The Gun Owners Action League is based in Massachusetts. The NRA incorporated in New York, headquartered in Virginia, but has a lot of members in Massachusetts. What the heck is the Attorney General's office talking about that you guys don't have standing to say that they're immune because the 11th Amendment protects them?
Well, it's kind of interesting. And one correction, Cam.
Yeah.
Just because Massachusetts now has to be different.
Yeah.
They're called assault-style firearms.
Yes. Oh, yes. You're right. Sorry about that.
Yeah. They're no longer assault weapons. Assault style.
Right. What is assault style? Anyway, I know what like animal style is at an In-N-Out burger, but I don't know what assault style means.
Maybe that's what you see maybe in an illegal concealed carry fashion show. I don't know. Is that good? I don't know. That's the best I could come up with. But as we said in our release, Cam, this really shows everything that we have seen since Bruin has passed. That the state, just like in past history when Brown v. Board passed, the bad states had a tantrum and suddenly declared themselves a sovereign state because they did not want to abide by a Supreme Court ruling. That's precisely what Massachusetts is doing now. And they have been doing ever since Bruin came out. But since the bill had passed over a year ago now, Chapter 135, they're literally making this up as they go along. Even the old assault weapons law, the language is gone. But the new assault-style firearms language is now in place, and it's different. It's a whole new animal. And in conversations with the Firearms Control Advisory Board, which unfortunately I sit on, their answer is, well, you had to know what the law was in order to understand what the law is. Excuse me? Wait, what? Can you imagine going before a judge as a defendant and the judge tells you that?
Right.
So basically the state is saying we do not have to comply with anything the federal courts say. We know better, and we're going to continue to do what we're doing. And if you don't like us, sue us, but then we're going to claim immunity if you sue us.
Right.
So it's,
I mean, yeah. And the other defenses that they raise, they say that the plaintiffs haven't stated a valid complaint under the Second or 14th Amendment, which again is the entire purpose of the complaint. That's absurd. They argue that, and again, they argue that this issue is not right, but you guys rebutted that in your initial complaint as well, because you note that if nothing else, you talk about that roster, right, which is yet to come out. We haven't seen that yet, but there are gun stores, including Pioneer Valley Arms, which is one of the named plaintiffs here, who they don't know what's going to be on that roster. They don't know what is going to be legal for them to sell when it comes out. So that's impacting their ability to determine what inventory they have, which in turn is impacting gun buyers in the state of Massachusetts. This uncertainty is having an impact, whether the state of Massachusetts likes to admit it or not. That also goes along, I guess, to their third affirmative defense, which is that you guys have not alleged any injury in fact, and so lack standing to prosecute this case. Again, there's just one of the injuries here. You don't have to wait for that roster to come out. The injuries are already happening because, again, these gun stores are operating in the dark. I presume that a lot of these stores are kind of going under the old standard, right? Which you say is no longer in effect. But I could sell this before, so maybe I can sell it now. But there's no guarantee that that's going to be the case. And in fact, under Chapter 135, it's the Secretary of EOPS, right? What is that? The
Executive Office of Public Safety and Security.
Okay, that individual can decide on their own at any time to place any firearm on or take it off of this roster, right? But to ban any firearm on a case-by-case basis whenever they want. They've got that discretion under the law.
Yes. Now there's two things that are an extended problem from what you just said. Number one, the new online firearms portal, because now you have to register every gun that you possess, not just what you purchase. The system will allow you to register a gun you can't legally own. So it's almost entrapment, because you're thinking, the system let me register it. I guess I'm okay. The other thing with the roster, which as soon as the Firearms Control Advisory Board started to draft something, I was very adamant, because when they said, well, we're just going to start off with the enumerated guns and then work from there. And I said, whoa, what do you mean start off? Oh, well, we'll just add to the roster as we go along. No, this is not an approved roster where you can add guns. This is a banned roster. Once you publish the banned roster, that's it. Because if it's not on the roster, everybody's going to say I can legally sell it or buy it. And the excuse is, well, no, you have to understand the law. You don't understand the law. How do you think the average person out there is supposed to understand? If you publish a banned roster, that's it. The other problem with the banned roster, Cam, is there are no banned assault weapons or assault-style firearms. There are heavily restricted ones, but not banned. So you're literally violating the law by creating the roster in the first place.
It seems like you need a law degree to understand the gun control laws in Massachusetts, because I confess, what you just said, I have no idea how I would comply with the law in Massachusetts. I don't know how anybody would.
No.
So now that the state of Massachusetts has submitted, its reply, I guess you guys get one more round of a response briefing, and then there's a request for a temporary injunction, right? So, that's kind of the next step in terms of a substantive goal here to achieve is to stop enforcement of this law permanently, hopefully, but at the very least, while this case is being litigated.
Well, it's interesting because, Jay Porter is our attorney on this particular case. So is Jason as local counsel. And they were kind of surprised that the state didn't just file a motion to dismiss. They answered the complaint. And in the complaint was, they seek relief, and part of it is dismissal with prejudice, by the way, which means we could never bring it back up again if that's what the court did. But it's kind of interesting. And to me, shows their arrogance now, that we're not even going to ask for a dismissal. We're just going to take you on because we think we have immunity and you can't tell us what to do. To some extent, it reminds me, remember the case Catano about the stun guns, where the high court in Massachusetts basically thumbed their nose at SCOTUS. And I thought we used to call it the SJC Smackdown, which is the Supreme Judicial Court of Mass. Ruth Bader Ginsburg, when she writes a Pro 2A case and admonishes the state court, you are on solid ground. And that's what happened. And maybe that's what will happen here, where they're so arrogant that they're going to get smacked down again. We can only hope.
Absolutely. Well, we'll be paying close attention to that case as well. Jim, as always, thank you for everything you do. Gun owners, actually, you can find them online at goal.org. If you're a Massachusetts resident, you really need to be a member. If you're not a Massachusetts resident, I think it would be helpful to be a member, but at least sign up for the alert so you know what's going on in the battleground state of Massachusetts. Jim and the folks there do a great job of providing updates on not only Kyle Culotta's case, but on litigation, legislation. So make sure that you're signed up for those alerts at goal.org. And Jim, I know that Massachusetts politicians are going to give us the opportunity to do this again very, very soon. So,
yes, unfortunately, yes.
Yeah. So until then, be well, my friend, and we'll talk soon.
All right. Thanks.
My thanks to my bearded brother, Jim Wallace, for joining me on the program today, and looking forward I'm looking forward to talking to Jim again. I'm not looking forward to what the likely conversation is going to be about, because it's going to be about gun control in Massachusetts. But I'm looking forward to having him back on the show before long. There is a hearing, I guess, on Friday at Halloween, a hearing on some gun bills. We've got a piece coming up about that at bearingarms.com later today. John Petrolino covering some of the shenanigans that anti-gun lawmakers are pulling there. So we may actually have a chance to have Jim back on the program next week talking about what happened at that hearing. Right now, though, let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. Now, again, like some of these cases, this is not actually a true recidivist report, but it is a sweetheart plea deal story. Here's the headline from the Lone Star State of Texas. Former North Texas police clerk jailed for stealing guns from evidence room. Okay. Jailed, right? Not imprisoned, which would imply being sent to prison. No, he was jailed. As CBS in Dallas-Fort Worth reports, a former evidence clerk for two different North Texas police departments with a history of theft accusations has begun a 30-day jail sentence after pleading guilty to 12 counts of stealing firearms. What the blank? Carl Edmondson reported to the Lou Sturrett Justice Center in Dallas on Monday of this week, where he will serve the sentence as part of a plea deal. He'll also be on probation for 3 years and be barred from ever working for a government agency again. I mean, why is that part of the terms of probation? Who the hell would hire him? Edmondson oversaw the evidence room at the DeSoto Police Department before taking the same job for the Midlothian Police Department in 2022. He was caught after a confidential informant told DeSoto Police in April of 2024 that Edmondson had stolen from its property room for years, giving firearms, tools, cameras, jewelry, and other items as gifts. When police searched his home, they said they found 18 guns in his master bedroom, which, I mean, for many of us, that's like a small collection, right? 13 of those 18 guns had come from the DeSoto Police Department's property room. Yeah, by the way, did you note earlier when I said that he was serving 30 days jail after pleading guilty to 12 counts of stealing firearms? I guess they dropped one of these charges. I don't. According to court documents, Edmondson told investigators he knew it was wrong, but once he took one, it was difficult to not do it again, kind of like eating potato chips, stealing guns from evidence rooms. Firearms case, not the only time that Edmondson's been accused of stealing. DeSoto PD also charged him with stealing drugs, seized as evidence in a capital murder case. Investigation led Midlothian PD to place him on leave. He was later fired, but a grand jury declined to indict him in that case, although they did indict him again in the theft of firearms. So, I mean, honestly, I'm just gobsmacked by this. you caught him red-handed. He admitted to doing it. Said, I know it was wrong, but I just couldn't stop. I was just like gobbling up Lay's, why offer him a plea deal? Is this not a slam dunk case at this point? And why let him off with such a light sentence? If you steal a gun from a gun store under federal law, you could be looking at 10 years in federal prison. It seems to me that stealing guns from an evidence room of a police department should be at least as serious an offense. What were any criminal cases impacted by the theft of these firearms? Did any charges have to be dropped because the evidence was gone, was missing? I am dumbfounded as to why this plea deal was offered to Carl Edmondson. Even the idea that, one of their own, I guess, but in this case, you're stealing from your department. I would think that would violate the code of brotherhood for the thin blue line. But for whatever reason, Carl Edmondson, 30 days in jail for stealing, after pleading guilty to stealing 12 firearms from a evidence room in the DeSoto Police Department. Unreal. Kyle Culotta, 4 months in jail, just awaiting the opportunity to post bail for possessing a firearm without a license. A month. It's the entire punishment for stealing 12 guns from a police department. All right, on to today's armed citizen story from Northern Virginia, Loudoun County, Virginia. Authorities evaluate self-defense actions in fatal Ashburn shooting. That's the headline. Now, the kicker is that the police in Loudoun County do not expect to file criminal charges unless new evidence is uncovered. So even though they are evaluating self-defense actions, it sounds like they've come to the conclusion that this particular incident was, in fact, self-defense. I don't know why the headline doesn't acknowledge that other than to downplay a defensive gun use, but for whatever reason, no, this has pretty much been determined to be self-defense at this point. It was October 25th, about 7:20 in the morning. The Loudoun County Sheriff's Office responded to a shots fired call in the West Marin condominium neighborhood. When they got there, they found a man with a gunshot wound to the chest. He was taken to a hospital eventually and later passed away. Leah Paul, who's a spokesperson for the Loudoun County Sheriff's Office, said that the shooter, who was detained at the scene, was later released without being charged, not injured in the incident. Paul also confirmed that investigators believe that the shooting stemmed from some kind of dispute between the armed citizen and the man who was killed that centered around the party's dogs, which had been in a fight. Police radio traffic monitored by the website Loudoun Now during the incident included references to a hostile dog at the scene of the shooting when deputies arrived. At one point, deputies at the scene said that they were hesitating to approach the victim, the guy who had been shot, because they were afraid that his dog would attack them. A supervisor told deputies, shoot the dog. If it's interfering with your ability to give this guy treatment or life-saving aid. That did not happen, by the way. The dog was later secured by animal control officers. And again, Leah Paul with the Loudoun County Sheriff's Office says detectives do not expect to file criminal charges unless new evidence is uncovered. So we don't know the exact circumstances of this case, but it appears that the armed citizen was acting in lawful self-defense when he shot the owner of that aggressive dog. We don't know what happened to the dog after it was taken into custody by animal control. Hopefully we'll get some more details about this incident, but if no additional evidence emerges, we might not. This could be a one-and-done story for the local media there in Northern Virginia. Finally today, our good deed of the day in the right place at the right time, willing and able to do the right thing. Salisbury, North Carolina, where a good Samaritan helped save a police officer from a knife attack at a local cookout restaurant. Cookout, by the way, is a regional chain in the, I guess, mid-Atlantic southeast. I don't know how far south it goes. We've got one in Farmville, Virginia. I consider myself to be somewhat of a fast food connoisseur, and I would put Cookout up there. It really does taste like a backyard burger. Really good milkshakes as well. Anyway, completely unrelated to the story. Just if you're ever in the area of a Cookout, now you know. Gosh, I'm hungry. Maybe it's the fact that I haven't had breakfast yet that maybe you started talking about that. Anyway, back to the story at hand. Salisbury, North Carolina, bystander helping Salisbury police officers subdue a knife-wielding suspect at a Cookout restaurant on Sunday evening, with the chief of the police there saying that the Good Samaritan likely saved the officer's life. It started about 8:15 Sunday night. Officers responded to a disturbance at the restaurant. When they got there, they encountered a 44-year-old man, Jamie Lynn Hunt, who is armed with a knife. During the struggle, Hunt caused minor injuries to one officer before a bystander intervened, sustaining several lacerations to their left hand in the process. Salisbury Police Chief said, "I'm grateful for the citizen who stepped in to help. His act of bravery likely saved an officer's life." A second officer on the scene deployed a taser twice, which allowed officers to take Hunt into custody. The officer, the bystander, the suspect, all transported to local hospital for treatment. The officer is okay. Has been cleared to return to work. The bystander, though, ended up having to have surgery on his hand because of the lacerations. Hunt, meanwhile, released from the hospital on Tuesday, now being held in the Rowan County Jail on a $100,000 bond. And police say at the time of the incident, Hunt was on probation for assaulting a deputy in Columbus County with a knife as well. So, still able to bond out. Not considered dangerous in North Carolina, unlike Kyle Culotta for simply possessing a firearm. Yeah, there you go. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program, joining me in the insanity in the criminal justice system. Let's do it again tomorrow. Maybe not deal with the insanity of the criminal justice system, at least outside of the recidivist report. But let's definitely do a Thursday Cam & Company. We'll see you back here whenever producer Jim gets the show posted, which is generally pretty soon after I send it to him. Be sure to check out BearingArms.com throughout the day on Wednesday and Thursday as well. We're keeping you up to date on all kinds of Second Amendment news. You know, we are getting closer to the start of legislative sessions. We're seeing bills that are being pre-filed, all kinds of court action taking place. So it is a busy time for our right to keep and bear arms, but we'll get you caught up on everything that's important to your 2A rights. And if you like what you see, I'd encourage you to become a VIP, VIP Gold, or VIP Platinum member. Use the promo code POTUS47, get 74% off your membership. It's a great deal. It'll last while the shutdown's going on, so take advantage of it now. We'll see you tomorrow. Until then, be well, be safe, be free.